Good afternoon, everybody. Welcome to the Virtual Elder Law Fair, Session 2. My name is Samantha Agwam, and I'm just here to help facilitate today's presentation. Hopefully you were able to join us last time. We did a presentation on senior scams and fraud, but that's okay if you weren't able to, because just like today's session, that session is available. It was recorded, and also the PowerPoint that went along with it was also being shared on our website for this event. So I'm going to head and move forward with, just to let you know, today, reminder, since you're here, you're probably interested in senior renter rights and reasonable accommodations. That will be presented by Lori Rolnick, who is with the Volunteer Lawyers Project, and Sally Santangelo with CNY Fair Housing. And before we get started with them, I just wanted to remind folks, if you're here, you probably successfully were able to register for this session and hopefully other sessions. And again, upcoming sessions you can register for, and you can also now view previous sessions that we have had. And also there's some great links to some resources of community partners and everything. So really great website, really great place to find all information about the Elder Law Fair. So keep that in mind. And just to let you know, some of the upcoming sessions, a reminder, we've got session 3 is going to be again on Thursday, starting at noon, just like all of our other sessions this month of May, which will be caregiver support and resources. And the following week, the last Thursday of May, we will have a session on estate planning. So we hope you can join those as well. And again, if you can't, we will upload the recordings of those sessions and any resources that we think would be applicable onto that website. So do look out for that. And I do want to take a moment, as always, to thank our planning committee. Really important to how we do this event. It couldn't be done without our partners from all of these agencies, AARP, special shout out to Deborah O'Shea and Robert O'Connor, Colin Gibbons with the Center for Court Innovation, Lee Gatta with the State Planning Council of Central New York, Jeff Unitas with the Onondaga County Bar Association, Joe Lance Bodo-Decker with the Onondaga County Office of Aging, Rachel May's office, and Senator Rachel May's staff, especially Ingrid Gonzalez McCurdy and Nodisha Hernandez, as well as Vera House, Jenny Ackley, and Volunteer Lawyers Project. My colleagues Sally Curran and Bethany Hemingway are major help putting on this event and these sessions. And lastly, just a shout out to Ellen Weinstein and Ed McCardle, who have also really helped out in getting the word out and have also contributed to this event in the past. And with that, I'm going to stop sharing my screen, and I'm going to pass it along to Sally Santangelo, who's going to start us off with the discussion of senior accommodations and reasonable. Thank you, Sally.
Thank you, Sam. I'm glad to be with everyone today. I'm the Executive Director of CNY Fair Housing. Let me get my slides to advance. There we go. We are a nonprofit located in Syracuse, but serving 17 counties of central and upstate New York. And we work to eliminate housing discrimination by, in a variety of ways. We investigate complaints of discrimination, including conducting undercover testing of housing providers who may be engaging in discriminatory practices. We do a lot of counseling and advocacy for individuals whose housing rights are being violated, particularly around the area of reasonable accommodations and modifications for people with disabilities, which I'll talk today about. We also provide legal representation to victims of discrimination, and we file cases in state and federal court. And we have actually a case pending right now against a senior housing provider that I'll discuss some of the things that we saw in that case and why we filed, and some of the things because it highlights some of the issues that we are looking out for and want to make sure that you're looking out for in your housing. We do a lot of education and outreach on fair housing rights and responsibilities. And lastly, we do research and policy advocacy to try to improve housing opportunity. So under federal and state fair housing laws, individuals are protected from discrimination because if they have a disability And under New York state law, individuals are protected from discrimination based on age. Under disability protections, there's a couple of different things. So one, somebody couldn't be denied housing because they have a disability or are a wheelchair user, for example, or have because of a particular type of disability, like a mental health disability. In addition, housing providers have to construct their properties to meet certain accessibility standards, and they have to provide for reasonable accommodations and modifications of their housing. Um, and unfortunately, we see a lot of violations of the law in these areas. And one area we've been looking at a lot lately has been related to those design and construction or accessibility requirements. So any buildings that contain 4 or more units, so any real apartment building with 4 or more units that are built after 1991 have to meet minimum accessibility standards. And that also includes any buildings that are substantially rehabbed, also have to meet those accessibility standards. And there's 7 basic requirements. I won't read them all off, but 7 basic requirements that these properties have to meet. And they have to be accessible, have an accessible entrance and an accessible route through the building. The common areas and public use areas have to be accessible. Doors have to be usable by a person in a wheelchair. They have to be able to be maneuver around have an accessible route into and through the dwelling. Light switches and other kinds of controls have to be within reachable, and they have to have reinforced walls so that grab bars can be installed at a later date if needed. And lastly, they have to have usable kitchens and bathrooms, meaning there has to be enough space for someone in a wheelchair to be able to maneuver a wheelchair in that space. These properties aren't required to be fully accessible, but they do have to meet these standards. And what we find is a lot of times a property will, follow the design standards when they are building or starting to build their properties, but decisions end up being made on construction sites that make the units that violate those accessibility standards. So some common examples of things that we see that are violations are thresholds at doors. Sliding glass doors are notorious for this, where they have a threshold that is too high, doesn't meet the accessibility standards, and makes it very difficult, certainly for a wheelchair, but also if somebody's using a walker or a cane or has other mobility impairment. Those thresholds are too high and don't allow for access. Those thresholds also can be inside the property, like the one in the image on the bottom right. Another issue with sliding glass doors is the width of the doors often don't meet the standard requirements for which is 32 inches, standard requirements to be able to maneuver a wheelchair out those doors. And those balconies, patios are part of the property. An individual has the right to be able to access their balcony or patio, and that's part of that accessible route through an apartment. Other issues we see are lack of access at common amenities like garages and storage spaces, maybe mailboxes that can't be reached, or we'll see storage units that have a step up to get into the property, or lack of access at a rental office. We've even seen places that the rental office was put on a second floor in a building without an elevator. So, if you couldn't use stairs, you had no way to access the rental office. Outside, we see issues too. Curb cuts are one area where we see insufficient numbers of curb cuts, or a really steep slope on sidewalks. And these are all standards that these properties should be built to. If you see any of these issues, or if this is something you're experiencing at your own property, you can always contact us and we can look into it and investigate. We have staff who's experienced at measuring and understanding what those accessibility standards are, and we can take a look at it. Sometimes we can even do it just from outside, but we can take a look and investigate further. The other area where we see a lot of issues related particularly to housing needs of seniors is around reasonable accommodations and modifications for people with disabilities. So a housing provider is required to provide a reasonable accommodation or to allow for a reasonable modification. And I'll explain what that means and what's required in that process. So an accommodation is any change or adjustment to the normal rules or policies or services offered by a housing provider to allow someone with a disability the full use and enjoyment of their dwelling. Common examples that we see are things like assistance animals when parking is normally, or when there's normally no pets allowed, or an assigned parking space. If you have someone with a mobility impairment and parking is normally first come, first serve, they can request an assigned parking space so they won't have to walk as far to their car, to their vehicle, so they can have a set space. And then they can know that when they leave their apartment, that set space will be there waiting for them when they return so that they don't have to walk an extended distance. Transferring apartments because of a disability related need, such as not being able to navigate stairs any longer. Trash pickup, sometimes we've asked for changes in how trash pickup processes have occurred because of individuals with disability related needs that made it difficult for them. Changes in snow removal processes, or sometimes leniency for behavior that violates a lease. If there's something that is a behavior that is disability related, we may seek leniency from the housing provider for that behavior. Now, reasonable modifications are similar, except they are structural changes. So physical structural changes to, again, allow a person with disabilities the full use of their dwelling and related facilities, so common area facilities, such as a laundry room, for example. Examples we see a lot for reasonable modifications include ramps, grab bars, maybe a sidewalk, a special sidewalk in a certain area to allow someone access or better access to their unit. Power assisted doors, where it might be difficult to open a door for an individual, they can request a power assisted door, or flashing smoke alarms or doorbells within a unit. And there's other examples as well. It could be something like removing lower cabinets to allow someone access to a counter, or a walk-in shower. There's other things as well. These are just some common examples of things we see. And I'll talk about what the process is for requesting those, and one of the most important things, who has to pay for those, in a moment. So under fair housing laws, disability is considered anyone who has a physical or mental impairment that substantially limits one or more major life activity. Some common examples we see here include mobility impairments or visual or hearing impairments, perhaps major diseases, mental illness, depression, anxiety, post-traumatic stress, and autism are the most frequent we see in the cases that we work on. With all of these requests, the issue comes down to what is considered reasonable. And courts have held that what's considered reasonable are any change that does not impose an undue financial and administrative burden, or would fundamentally alter the housing provider's operations. Now, undue is not a clear word either, so it really comes down to a case-by-case basis, and it looks at factors like what are the resources of the housing provider, what are the costs of the accommodation or modification, and what kind of benefit does it provide, and are there other options? Municipalities, local governments are also subject to reasonable accommodation requests. And we see this sometimes with ramps. If somebody might need a variance to have a ramp installed at their property, even for homeowners, this sometimes comes up, and the municipality is also required to allow for accommodations if that's necessary. Insufficient reasons for denying an accommodation or modification include aesthetics, or claims that everyone's going to want the same thing, or that it's not fair to other individuals. Or that there's a reasonable cost. Sometimes a modification or an accommodation is going to cost the housing provider something. For example, if somebody requests an assigned parking space and it might need a sign, it might need to be painted, and the housing provider would have to pay the costs of those things, as long as it's a reasonable cost. Now, with reasonable modifications, those structural, physical changes to like a ramp, in federally subsidized housing, the housing provider has to pay for the cost of all modifications. In private housing, which is the majority of housing that we have in our house locally, the tenant is responsible for paying for modifications within their apartment. So like a grab bar and a shower, the tenant would be responsible, while the landlord is responsible for paying for some modifications to common areas. So if it was a power assisted door, an automatic door to an apartment building, the landlord would be responsible for that cost. It depends on if the account or the modification is used by lots of individuals or just by that one tenant. If it's something that would benefit more than the one tenant, then the landlord is generally responsible. Also, if a modification is needed because the housing provider failed to comply with those design and construction standards, then they have to pay for the modification also. So if you have a sliding glass door that doesn't meet accessibility standards and you can't access your balcony or patio because of the threshold is too high for that to get out in a wheelchair or with a walker or it's a trip hazard, and the landlord didn't follow the right standards, for the developer or builder didn't follow the right standards, they would have to pay to replace that door in most circumstances. And again, we can help determine that and figure out those situations in which they would have to pay for that, whether it's replacing the door or paying for a ramp or something to allow access. If someone's requesting an accommodation or modification, they don't have to make the request in a particular way. They just have to make their needs known to the housing provider. We do, of course, recommend that requests are made in writing and that you ask for a response in writing. And we also have staff available to assist with that, help draft letters or accommodation or modification requests. Your landlord or housing provider might have a particular process they use. Some bigger housing providers will have a form that they have tenants use for an accommodation or modification. And they can ask you to use that process, but they can't require that you use that particular form. If a person's disability is not obvious, they should be prepared to provide information from a third party that verifies that they meet the Fair Housing Act's definition of disability, describes the accommodation or modification that they need, and shows the relationship between their disability and the accommodation or modification. We have sample forms on our website and templates on our website that make sure there's access to and are shared as part of the resources available after this, so that you can have a link to those as well. And these forms will be something you can take right to your medical provider to request. And it doesn't have to be a doctor. It can be a therapist or a social worker, anyone who has a familiarity with the disability-related need. Housing providers also cannot charge additional fees as a condition of granting the accommodation or modification. That includes pet fees and pet deposits for assistance animals, parking fees for assigned parking spaces, or transfer fees if somebody needs to switch units because of a disability-related need. They also can't reword the fee and try to call it something different, like an administrative fee. We actually recently filed a case in federal court against a senior housing provider who has 3 properties in Onondaga County. And the lawsuit alleges that they were charging tenants fees for assigned parking spaces, $350 for an assigned parking space that we believe should have been provided as a reasonable accommodation or modification. So we do have that case pending against Clover Properties that operates Camillus Point, Buckley Square and Morgan Square apartments. In addition, housing provider, that case also alleges that the housing provider was charging additional fees for increased rent for more accessible units, like first floor units or near an elevator. And we argue that those are amount to disability discrimination under fair housing laws. So if you experience something like that, being assessed a fee for requesting a parking space, for example, or a assigned parking space, you can certainly contact us and we can look into it further. Senior citizens are also entitled to lease terminations under New York State's tenants' rights law. So you could ask for a lease termination as a reasonable accommodation, but even better, New York State actually has a process that allows for senior citizens to terminate their lease for a couple of reasons. So either a tenant or their spouse who are 62 or older can terminate their lease if they have a physician certifies that they are no longer able, for medical reasons, to live independently, and that they have to move to a higher level of care or move with a family member. Also, if you are moving into subsidized low-income housing or any other senior housing, you have the right to terminate your lease as well. And that way, you don't have to pay the remainder of that lease. A lot of times senior housing has long waits, so it's tough to, you get on those waiting lists, and then you aren't sure if you should sign your lease or a new lease or not, because you think you might get up on that waiting list and get into that housing you've been waiting for. You don't need to worry. You have generally the right to terminate the lease. And again, you can always reach out to us if you have questions about whether your move would qualify. If you want to exercise that right under those lease terminations, you do have to provide proper notice, which gives the termination date, which has to be more than 30 days from the date that the next rent payment is due. So basically a calendar month, if your rent's normally due the first of the month, you would have to give notice before 1 month before your rent is due. So before the first of the previous month that you want to leave. And you have to have that physician certification that you're no longer able to live independently for medical reasons. If you are moving in with a family member, you have to have a notarized statement from that family member that explains that states that you'll be moving into their residence. Or other documentation that you're going to be moving into one of those covered properties. One last issue that we see in terms of senior housing and seniors in housing, I should say, is related to harassment. Fair housing laws protect individuals from and protect tenants from harassment based on their protected status, which in New York State includes age or gender, where primarily the issues we sometimes see harassment based on race and national origin as well, or disability. Some examples of behavior that could be harassment that we've seen include sexual harassment, such as lewd comments or gestures by a housing provider or maybe the staff. We've had instances where we've had, for example, a maintenance person at a property making lewd and inappropriate comments to the residents that made them uncomfortable, that went on for a long time, and they felt harassed in those actions. Or it could be something like derogatory comments about a disability or derogatory comments about age. Excessive lease violations or maybe unjustified lease violations could be another type of harassment that you might see coming from a housing provider. And then lastly, we see housing providers that are sometimes very paternalistic. They have a lot to say about their tenants' lives and want to, sometimes seem that they want to help, but maybe overly involved in what's happening with their tenants. And sometimes that could be harassment. It could be other types of discriminatory behavior. It could be a difference in treatment because of age. If a housing provider is getting overly involved with their tenants potentially. And again, this is something that we can always assist with and trying to understand what's happening in that particular situation. If someone is a victim of harassment, they should contact the police if needed, if they feel threatened, their safety if they feel that their safety is threatened. They also can document or record interactions with the person harassing them, including video or audio recording. You're allowed to record somebody in New York State without their knowledge. So if there's somebody who's always giving you a hard time, maybe it's someone you see at the mailbox or doing laundry or in the parking lot that's giving you a hard time, you can record your conversation with them, put your phone on record and just keep it in your pocket if you know you're going to run into that person and they're going to give you a hard time. Keeping a journal and writing down what's happening while it's happening can be really good evidence if there was a harassment case as well. And you should notify your housing provider, let them know about what's happening as well. If you talk to other tenants who might be seeing the same thing, experiencing the same thing, it's a good idea to have them also notify the housing provider. And with that, I will open if there's any questions, and I'll also stick around as well after Lori's presentation if there is any questions. Oh, now I can see the chat. There are questions. I couldn't see it earlier.
Yeah, and I think, Sally, it's really just the last one. A couple were technical issues. So the one,
okay.
Yeah, so that very last one would be a question for you. And that might be something that Lori could also add to. And basically, this person has asked, I have a patient that is in a senior retirement community, and that is in a month-to-month rental. Does he have to give 30 days notice if he's unhappy with where he is? He's looking at other housing.
Yes, they should give 30 days notice. In almost all situations, the tenant should have to give 30 days notice. If there was something where the tenant was felt really unsafe, or there was a situation where they were being really harassed, maybe there would be an argument, or to give less notice, but generally 30 days would be required. So today is May 13th. If you were to give notice today, it would be for July 1st. So it would be because it's a full calendar month plus the remainder of the month. So.
Right. Good point. Thanks, Sally. And I did just get a couple other ones. I hear this one is are all private landlords required to have accessible properties, or can some choose not to?
So any property that is built after 1991 that contains four units or more. So an apartment building with 4 units built after 1991 has to meet the minimum accessibility standards. Now, that does not mean they have to make every unit fully accessible. There's different standards depending on where the unit is in the building, whether there's an elevator, but they do have to meet those accessibility standards if they're built after 1991. If it is a property that's older than that, it does not have to be made accessible. However, if you have somebody who requests a reasonable modification to make the building more accessible, then you would have to allow for that if it's reasonable. So something like having a ramp put on a front of a property that is generally considered reasonable by courts. Putting in a walk-in shower, roll-in shower, or walk-in shower is generally considered reasonable if it is an older property, and that applies to private landlords as well.
Great. And Sally, we did get a follow-up question with that one gentleman who's afraid about losing the opening in the new place with waiting for the 30 days. And I will suggest probably that, a lot of what you had spoken about was a lot of case-by-case basis, right? So sometimes you need to know a little bit more. So it may be a good idea, right, to reach out to your agency too, and so you can really talk through what's going on as a particular person's situation.
Yes, for sure. So if, like, for example, because there's a shortage of accessible housing, if it is that the new unit is wheelchair accessible and therefore particularly hard to find, there might be a circumstance where they could ask for an accommodation to get out of their lease earlier. So there might be some instances where, depending on the specifics of the circumstance, that
Right.
specific case, there may be some things that could be done. So feel free to reach out to us. Easiest way to reach us is, well, you can call our number directly, but also email us at I'll put it right in the chat, but info@cnyfairhousing.org.
Thank you very much, Sally. Appreciate it.
Absolutely. Thank you for the opportunity.
Absolutely. And with that, I will pass it on to my colleague, Lori Rolnick, to talk a little bit more about senior renter rights. Lori.
Everybody, how's everyone hanging in there? A year ago, I don't know that we would have done this in a virtual way. How far have we all come during these really crazy times? So I have a PowerPoint. We're going to start off with it, but I am not going to use it exclusively. We have some other things I'd like to chat about as well that I'll bring you directly to some websites, but I will share this PowerPoint. My contact information is here. I'm the program director for the eviction defense program here at the Volunteer Lawyers Project. And because I am a lawyer, we are not creating an attorney-client relationship by having this conversation. This is, of course, just general knowledge. And if you wanted to consult about a specific situation, that would be a different situation. So what I'm going to go over today is why and how we do what we do, a little bit about how evictions happen in the rental cycle, because it is a cycle, COVID-19 responses, what's going on today, right now, and a little bit about the tenant hardship declaration form and the county rent relief that's available. That I think we may have some landlords on the line. We usually do. So hopefully this information will be useful to landlords and to tenants. Why do we do what we do? A huge part of my goal in this program is to do whatever we can to help improve systemic inequity that we have throughout our city. I've linked here to Syracuse, the map, so segregated Syracuse, because over the past few weeks, they have been doing on cnycentral.com a really extensive review of the history of our city, and that no one of us should feel individually responsible for that. This is not about making anyone feel bad. This is about how do we move forward in a situation where we've had things that for decades have harmed families, have caused families to not be able to build generational wealth, for example, and a lot of it was because of color. If you look at this map, this was one of the original, what we call redlining maps for the city of Syracuse. And these areas in red and yellow are where the federal government determined that they would not loan money easily to families to maintain homes or build homes in the areas. And these were areas that were predominantly populated by African American and minority households. This goes back decades. This map is from the 1930s. The one from Matt Mulcahy, which I will show, actually was found to be from 1919, where the city planner literally labeled out our neighborhoods by who he thought lived there. And we see this down through the ages because in recent years, you'll see the dark areas are where we have most of our eviction cases coming from, and they follow right in line with that map. So our program is actually designed to engage volunteer attorneys to help tenants who are facing eviction. It's really surprising to a lot of people to realize that there is no right to an attorney when you are facing the loss of your home or your rental property, which is crazy to me. We're working toward more rights in those areas, but because the foresight, I would say, of Deborah O'Shea, who helped develop our program over a decade ago, the Volunteer Lawyers Project and volunteer attorneys throughout our community dedicate their time to helping people who are going through this very scary prospect. Now, people don't realize that the Syracuse City Court particularly is really busy with evictions in most years. About 5,000 cases are filed every every year, and our agency ends up representing between 800 and 1,200 a year. We also work behind the scenes to help improve housing quality, to influence legislation whenever possible, to improve the landlord-tenant relationships, and again, fix systemic inequities wherever possible. We help tenants to reduce judgments, stay in their apartment as long as possible, because the more transition time, the better a chance that they'll move to a decent place the next time. Eviction's just terrible. There's so many books and so many things that have been written about that, but we don't want cases to end in eviction. We want to start in the beginning with the end in mind. So thinking of renting as a cycle, most cases do not end up at eviction court. So I don't want anyone to think that most people are going to end up seeing me at the courthouse door. You're not, hopefully. But if you are, we're there. And let's look at a rental cycle from the beginning. A landlord must provide all the things that Sally just talked about in great detail, but a property has to be fit for human habitation. It has to have working electrical, plumbing, locks, privacy, heating, ventilation systems, working appliances when they're provided, smoke and carbon monoxide detectors, and disclosure of any known hazards. People may not be treated differently because of all the protected categories. Sally's gone through a lot of this, so I actually am going to try to stop this PowerPoint if I can figure out how. Oh, and we have to have working smoke detectors. So I am the daughter of a Rochester fire chief. So smoke detectors are super important. They totally save lives. So they must be in all rental properties. A tenant can be required to maintain the batteries on a smoke detector, but they are required. And for some reason here, all right, how does someone be a great tenant? How do you, if you're renting, become a great tenant? Well, the first thing I would say, of course, is to okay, the teens today, I've got teens in my household, they would say, don't ghost your landlord, right? Don't ghost your tenant. Don't ignore them. Make sure that you have a working relationship to the extent possible. Communicate with them about things that you're experiencing that might be important to the rental situation. Let them know if you're having difficulties, for example, paying the rent, or you need help with things. It's really important to build trust in that relationship. And it goes also for landlords to make sure to try to communicate with their tenants. If you notice something's wrong, don't wait 3 months for them not having paid rent without trying to reach out, and then, filing a lawsuit when it's too late later on. Start in the beginning by having a good relationship to the extent possible. Also, we want tenants to remember to pay their rent and pay it on time. That is the number one way, I think, to avoid seeing me at court. Also, you are required by law, if you are a landlord, to give a rent receipt if a tenant requests it. We advise all tenants to not give their rent without getting a receipt. If you're having trouble with that, reach out to our office, reach out to an attorney. You have a right to a rent receipt, particularly if you've requested the receipt. We advise all tenants to, keep the place nice, keep it in good shape, and remember that it's someone else's property. So keep it clean, keep it nice, respect the other tenants who are sharing the common areas with you. Just basic living in quarters together. So what we see a lot of is people who call our office with concerns about housing quality. Syracuse is full of old houses that may not have been maintained as well as they should have. And everyone is aware of the situation that we're seeing at Skyline and at other large properties. And the city is trying to attack these housing quality issues in many different ways. I like to say I am cautiously optimistic that we will see an improvement in housing quality in our city because of all the different ways that we're attacking the problem. But tenants should know that even in a pandemic, even if you're not able to pay the rent, even if you're having issues, financially, your landlord still has an obligation to keep the property habitable and safe for the tenants who are occupying it. And we really recommend at this point calling our codes department, who now has a new ability to fine landlords and to get those cases in front of our new Bureau of Administrative Adjudication. Let the city know if you're facing housing quality issues, and also seek legal advice before withholding any rent. So we hear all the time from tenants that, like, maybe 6 months ago, the landlord didn't respond when they asked them to fix something, so they just didn't pay the rent. That's the quickest way to get evicted. So if you're going to withhold rent, seek legal counsel before doing so that you're doing it in the right way, that you can document any complaints that you've had in the property, that you can document that you have let the landlord know about the issue and they are still refusing. It helps, but is not required, to have a third party take a look at the situation and have codes come in and do an inspection and declare what needs to be fixed, and having all those documents in order before you'd start withholding rent will help you in the long run. Also, most importantly, if someone's considering withholding rent, don't spend it on Sally's birthday present. As nice as Sally is, you're going to need that money eventually, because eventually a court will decide how much rent should have been taken off because of conditions that were in the property. And if that rent is determined to be due and it's not able to be paid, you can be evicted for non-payment. So withholding rent for property conditions is something I really advise people get advice on before they do that. I was going to go over the lease termination being allowed for seniors who need to move into residential care facilities. Sally did a great job covering that. And one of the reasons why that's important is that we've seen that even in advertising for seniors. There's a prominent senior apartment complex in Fayetteville, for example, that advertises that, you don't have to have the hassle of a lease. So if you needed to have care, you could get out quickly. You would only need to give a 30-day lease, but you already have those rights. And having the protection of a lease is super important, because it helps you to make sure that your rent will remain stable for at least a year. It puts everything in writing for at least a year, or for whatever your term is. But having a lease protects the tenant. Not having a lease can only benefit a landlord, really, honestly. I mean, unless you think you're going to have to move for some other reason, or you want the temporary nature of a month-to-month lease, that's your choice as a tenant. But to advertise this when it's already a right that a senior has is just appalling to me. But that's okay. I'll get off my soapbox. So what happens when it's time to go, like to end a lease arrangement? There are notices that are required, and generally, as Sally has already said, 30 days notice is what a tenant has to give a landlord. And that's if they're on a month-to-month arrangement, or if they're at the end of a lease term and they're not planning to renew it. So a tenant can give 30 days notice. A new law came into effect in 2019 that requires the landlord to give more notice to a tenant based on how long a tenant has lived there. So if it's a year or less, or it's a year-long lease, then they only have to give 30 days, just like always as in the past. If a tenant has lived there for between a year and 2 years, or has a 2-year lease, it's 60 days notice. And if a tenant has lived there for over 2 years, a landlord must give 90 days notice before terminating the lease, or changing the rent, increasing the rent by more than 5%. So now we have a 30, 60, 90-day notice required from the landlord. And I'm happy to answer any questions about that. So what happens is, if a lease has gone past a year and a tenant continues to pay and the landlord continues to accept the money each month, then it automatically becomes a month-to-month tenancy on the same basis as the lease. So all the different terms of that lease would still apply. And it's really important when you first go into a place that you look at the terms of lease, understand what you're getting into, and ask an attorney to look it over. That's what we're here for. We're happy to do that. So once a lease has ended, A security deposit in New York State must be returned to a tenant within 14 days, or a landlord must give a list of reasons why not. But there's also a new provision that requires a landlord to do a walkthrough within 14 days of termination of the lease or the end of the lease, and to give them a list of anything that they might charge for. So they have an opportunity to fix that situation and, make repairs if necessary to avoid losing their security deposit. How do people end up seeing me at court? Good question. There are two basic types of eviction cases. If people don't just normally end their lease on their own terms, which most do, they're either in violation of a termination notice. So if a landlord gives someone notice that they're terminating the lease and the tenant stays beyond that time, that's called a holdover case. And the landlord can bring it saying, I have given someone notice, they're still there. This is a holdover case. Now, in New York, a landlord does not have to have a reason to terminate the lease. It can be just because they don't want to continue renting, or they want someone from their family to move in, or they don't have to give a reason, but it can't be a bad reason. It can't be retaliatory. It can't be discriminatory. It can't be because a tenant has called codes. In fact, it's presumed that if a tenant calls codes, that it is retaliatory if a landlord makes any major changes to the lease arrangement afterwards, within a year afterwards. So we look at court and how we end up at court. There are due process requirements for either the holdover or the most common type of case that we see in Syracuse City Court, which is non-payment. So non-payment cases are exactly what that sounds like. They're actually labeled that way on the court paperwork, holdover or non-payment. A non-payment case is like treated almost as disrespectfully as repossessing a car or taking back something that you couldn't pay for. They treat it like a commodity, not like your home, which is hard to swallow. And they are summary proceedings at court. A landlord must give required notices before they can bring these cases. So they have to give a 5-day notice saying, hey, we haven't gotten your rent this month. A 14-day notice saying, okay, you have to either pay or leave within 14 days, or I'm bringing you to court for an eviction. People get really nervous and they think they have to leave by that 14th day, but they don't. If they are still there after the 14th day, that's when the landlord would file an eviction case. There's a lot of time built into the process, and at any point along the way, if the tenant is able to pay the rent, then the landlord must take it and the case would go away. I actually have quite a bit more to cover, and I'm sort of running a little low on time here. So I'm going to skip right to where we are now. So I'm going to actually share my screen because I like this little picture. This is where we are now. COVID-19 has created some moratoriums, right? And we have this guy kicking the can down the road because he's thinking, because that's what our legislation has kept having happen. We keep kicking the can down the road, and we're creating moratoriums where landlords could not evict tenants. All right. And throughout all of this, people misunderstood the word moratorium. They thought it meant they don't have to pay the rent. No one has waived rent requirements. So rent is still due. All right. Nationally, we're expecting an eviction tsunami. We really are. And nationally, I'm going to stop sharing now because I'm done with my pretty pictures, but you'll get a copy of everything that's in writing here. But nationally, the CDC did put out a form where a tenant could claim to have a COVID-related financial hardship, testifying that they have tried their best, made their best efforts to pay the rent, that they have sought assistance, and that should postpone any eviction process until June 30th. Now, nationally, they're dealing with that. Some jurisdictions have said that they didn't have the authority to do that. Some have, but we don't need to worry about that in New York State. The CDC form should not apply in New York State at this point because New York State's protections are greater. New York State has put in through the COVID-19 Emergency Foreclosure and Eviction and Foreclosure Prevention Act, a new provision that actually creates a tenant hardship declaration form and creates an obligation for the landlord and for the court to get this form to tenants, where they can certify to the court that they've had financial hardship due to COVID. That doesn't just mean a job loss or a loss of income, but it could mean increased expenses, increased childcare obligations, COVID-related expenses, and difficulty finding a new apartment that's suitable during a pandemic, which I think everyone pretty much qualifies for, or that moving during a pandemic causes a significant health risk to someone in the household. So if A or B or both can be filled out, you just check it off, and I can show you actually, and I think this is important that we take a look at what does this form look like. I'll do this very briefly, but we have this form available on our website up here where it says Get Help under Housing and Homeless Advocacy, Renters' Rights, and CNY. There are a lot of resources here, but right here is the hardship declaration form, and it is available in many, many languages right there on our website. So you could go right to the website. It does say that you cannot be evicted until at least May 1st. That has been extended until August 31st. And this is what is driving landlords batty, because it protects a tenant who signs this form. All you have to do is go onto our website, type it in. It's a fillable PDF. You can type in Oak Street, check off A or B or both, sign, print, date it. There you go. Give a copy to your landlord, give a copy to your attorney if you have a case, get it to the court if there's a case going. That stops all proceedings, even a pending eviction where there's been a warrant issued, until at least August 31st. This is so the parties have time to try to seek rental assistance through the county and through and this is statewide, so our rental assistance is still in the process of being distributed and of getting the process going. So I'm going to share with you also the county website. Any tenant or landlord in Onondaga County can apply for this rent relief. It is at ongovrenthelp.com. I'll also pop that in the chat later, but it's in all the materials, ongovrenthelp.com. Landlords can apply. It is tenant relief. So the tenants must qualify and be eligible for the assistance. There's I'm a renter, I am a landlord, general public information, and these little red apply now buttons. So do apply if you think you might be eligible. Do apply if you think your tenants might be eligible. Who's eligible? Anyone with 80% or below area median income, and they're prioritizing 50% and below. Any tenant in our county must apply through the county. Anyone anyone in our county who applies through the state program will get kicked back. They must apply through this county program at ongovrenthelp.com. And anyone who is not in our county must apply through the state or check their respective counties. So landlords, as I've said, are upset because if a tenant has put this in place, the only way to evict is by claiming that they're an objectionable tenant, meaning that they are causing a safety issue or a bad environment that's harmful to other tenants. It's not just about someone being annoying to the staff. It has to affect other tenants. It's a high burden of proof, and they've got to prove that before they'd be allowed to evict someone who has this hardship form in place. So that's why that hardship form right now is like a magic ticket out of eviction for anyone. If a marshal comes to the door with a warrant, a tenant can hand them this form. If the marshal comes to the door to do a lockout, they can hand them this form. They can bring it to the court. It will stop all proceedings. And so after August 31st, I'm really, really hoping that people use this time wisely to get the rental assistance in place, to work out settlement arrangements, to work out payment arrangements. After August 31st, we believe that the new Tenant Safe Harbor Act will still apply, and that means that someone who could not pay because of a COVID-related financial hardship can have a judgment against them for the back rent, but is not supposed to be evicted from the property for that non-payment. So we have to be careful to watch to see if the landlords start filing more of those holdover cases that we talked about. I suspect they may, and I've seen some new ones coming through, but they're not supposed to be evicted if the non-payment was COVID related. It is a brand new protection, but it's not a moratorium. A tenant has to show up and respond and present this hardship form and present their defenses at court in order to qualify for them. So it's not a blanket moratorium. And I really want people to know that. So there's two parts to protections right now: apply for the rent relief and get that hardship form to the landlord and to the court. It's really important now because landlords are super frustrated for everyone to understand that only a marshal or a sheriff with a court order in hand can lawfully lock out a tenant. Self-help eviction is illegal. It is a crime. It has always been illegal, but it was made a crime in 2019 with all the new landlord laws that came into effect. Our PAPL 768, again, this will be in the materials, but it is a crime to lock someone out without their consent. It is a crime to change the locks, to put things out on the curb, to try to intimidate or harass a tenant to leave unlawfully unless you have a court order. There's guidance out there for law enforcement agencies. We're trying to make sure all the police departments know about this and that landlords are aware, because the criminal penalties are for up to a year in jail and $1,000 to $10,000 per instance. And our offices, legal service agencies offices, are well aware and are doing what we can to protect tenants' rights too. So this has been a lot of material, and it will all be available to you in the PowerPoint. And I think we should open up to any questions, so I don't want to run completely out of time here.
Thanks so much, Lori. Appreciate it. I don't think I see any questions. I'm sure there are many, but to come up with them, I know everybody needs to absorb all this information that you've provided, which is great. So I think what I will do is I'm just going to share my screen real quick and just put up our website again for this event and everything, so that, as Lori was referencing, we will be putting this on the website for the events, as well as a recording of this session. So if you missed something, you need to hear it again, what Sally and Lori have talked to us about, please go to this website. We'll try and put that up as soon as we can, get those materials to you quickly. Also, Sally, you put in the chat, I figured I put the number as well. A lot of what Lori and Sally talked about is a lot of case by case, right? And there's a lot of numbers, there's 30-day, 60-day notices. So we understand that. So hopefully, you could get your answers from the materials that we provide on the website. But any questions that you can't get answered there, if you need help connecting with the parties that I presented today, feel free to reach out to this phone number, 315-579-2579. That's my number. And there's an email there as well, elder@onvlp.org, if there's still something that you're unable to get answers about. And I will also remind us about what's coming up with the next couple sessions. Hopefully you can join us. And again, if you can't, look out for the recordings and the materials and resources on that website when they do come in. And I will stop sharing my screen and make sure that we don't have any quick questions before we take off.
I'll just add in that in the chat, I've dropped in a SurveyMonkey link. We really value your feedback about how this session went, and we use the information to help us determine what presentations we should do in the future. So please just take a moment to click on that link. It'll also be coming in a follow-up email to all of those who attended. So thank you so much. We so appreciate that you take that time.
Great. Thank you, everybody.